Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in this video I'm going to be talking about settlement agreements from the employer's perspective. If you are an employee looking for advice on settlement agreements, there is a separate video aimed at you, so you need to find that one. I'm wearing a different coloured scarf in that one. So why does an employer want a settlement agreement? Well, the main reason an employer is likely to want a settlement agreement is that they're going to want to put some kind of line in the sand and to know that once an employee's left and they've paid them what they've agreed, that there won't be any legal claims arising from that employee. So there won't be claims to the court, there won't be claims to the employment tribunal. But it may also extend to other things like making sure there aren't any grievances that are going to be raised, for example. Obviously, there will be other things that feed into the settlement agreement, so an employer's considerations around confidentiality, protecting their reputation, other political reasons that there might be behind the need for a settlement agreement. Settlement agreements have to have certain key ingredients in them, so that does drive a certain amount of similarity in the paperwork. There are certain things that by law has to be in them for them to be a binding settlement agreement, and the key one there is that the employee has legal advice from a lawyer. So the employer typically is expected to pay a contribution towards the employee's legal fees there because they're the one driving them into the arms of the lawyer. We'll come on to legal fees again later on. Often there are other things that we would advise employers to put into settlement agreements. So where us lawyers have had experience of one employee doing something, we tend to draft around that as a precaution going forward. So I'm thinking of things around, employees not making derogatory comments about you after they've left, those sorts of clauses. So there will be certain things that we would recommend that you would put into a settlement agreement from that perspective. It can be quite tempting to make the documents a bit one-sided because you're drafting them, you're thinking about the situation from your side of things, but it can also be really helpful to think about the document from the other side of things. And I think that's one way in which I can help my employer clients, because I do a lot of advice for employees as well. I can draw their attention to the things that the employee is likely to be looking at, so references, what they're allowed to say when they leave, etc. What am I doing when I'm advising on a settlement agreement? I think there are a couple of main functions of using somebody such as myself. I'm going to make sure that the document that you're using is tailored to your specific circumstances. And that's where I'd like to really emphasise that no two cases are ever the same. They are always different, similar, but there will always be individual circumstances. And things are always changing, and we shouldn't really just be wheeling out the document that we used last time. For example, this week I've been advising an employee in relation to specific immigration issues around a settlement agreement, where they've needed to sell some equipment to their employer, some tax planning considerations. So there are lots of things that can feed into the settlement agreement where you might need help. The other main thing that I'm going to be doing is advising the employer how to pitch the offer that they're making to the employee, budgeting around the costs of the settlement agreement, and where best to aim that, and how to achieve what you're trying to achieve swiftly and sensibly. Sometimes I'm actually reining in what employers are spending and helping them to reduce their spend on these things. I'm definitely going to be looking at things from a tax perspective. Lots and lots of times I'm seeing employers getting this wrong, particularly since we've had big tax changes. We've now got the concept of a post-employment notice payment that we need to worry about, and advice really does need to be taken before you start promising things to employees that they can have tax-free payments, for example, as that may not be the case. I'm also going to be protecting the employer more widely than just thinking about the legal claims that somebody needs to give up. So it might be in relation to making sure there's a proper handover, that we've got the employee's cooperation after they've left if we need it in the future, making sure the employer's property is returned, and that can extend to some intangible things like connections on LinkedIn, ensuring confidential information and intellectual property is protected. Quite often what I see in people's contracts of employment around that can be quite poor, and we might need to build things up in the settlement agreement, and that's our opportunity to correct it. It might be around introducing or reaffirming restrictive covenants, so things that restrict what the employee can do after they've left. It might be managing people's communications about their departure. So what are we saying internally, what are we saying externally, and controlling some of the negative things that employees might do once they leave as well. The document itself doesn't become binding until it's signed by both parties. Often I see employers forget that and start to, for example, put in place the reorganisation that they're intending to put into place before they've got the paperwork signed off, telling colleagues, for example, that somebody's gone before things are actually agreed. So we need to be careful around that, and using a lawyer can help you make sure that the negotiations that you're having are properly protected as protected conversations or without prejudice discussions. I'm always looking to protect my clients with tax indemnity provisions. So if HMRC come to a different view on what we've done to the view that we've taken on tax, that there is that ability for you to go after the employee for tax in relation to that. We've already mentioned property being returned. We might need to think about gagging an employee in terms of what they can say after they've gone. But we are going to be focusing on that line in the sand that I've mentioned earlier. In particular, we want to make sure we've signed away claims of breach of contract, unfair dismissal if that's relevant, any discrimination on the grounds of protected characteristics, but also dealing with things like back pay, holiday pay, commission, bonus. There are lots of things that can come into the settlement agreement. There are certain promises that we might want to make the employee make in signing the document. Often we use the word warranty, that's just a word for a promise. So, for example, that they haven't done something that would justify us dismissing them anyway. They haven't got another job lined up because we don't want to pay them a lot of money if they've already mitigated their losses. That they haven't got any awareness of a personal injury claim that they might bring against you, and that they haven't already breached the terms of the agreement. So, for example, going to ACAS for early conciliation or breach of confidentiality. And I would often be looking to put in place backup provisions within your document that if an employee has breached any of these things, then you can either avoid paying them or go after them for their money back. I mentioned legal fees earlier. It is normal for the employer to pay for those because you are seen as driving the person into the arms of the lawyer if you want a settlement agreement. This can be a problem area because employers often expect this to be done on the cheap, and the employee, of course, is likely to want their legal fees in full so that they aren't out of pocket, and that tension between the two can really lead to some situations where employees are leaving with quite a bad taste in their mouth. So it is worth thinking quite carefully about what you do in that regard. If there's going to be a big gap between when we sign the agreement and when somebody leaves, there is that possibility of fresh problems or claims emerging in that gap. So we may need to get the documents to be signed twice, or reaffirmed is quite often the language that's used, and that can lead to a second round of paperwork and more cost, but that is the only way to fully protect yourself, and that minimal cost may well be worth it in the long run. In terms of how long the process is going to take, that's completely unique to each individual circumstance, so it's hard for me to give you broad rules of thumb there. By law, you've got to give somebody 10 days to think about the offer that you've given them. So we're probably talking a few weeks to get a settlement agreement agreed and signed off. But I've known it to happen much more quickly than that, where somebody's quite happy to enter into agreement, but equally I've known negotiations to go on for months. So it does depend on the complexity and the circumstances. One of the biggest aspects of settlement agreement negotiations, I think, is the psychology involved. And again, that's an area that the solicitor can help you with, because we have expertise in that, in terms of having done lots and lots of these things over the years, and can assist with perhaps the best way to achieve what you're trying to achieve. In terms of other mistakes that I sometimes see employers make, employees often have more than one relationship with an employer. So they might also be a director or a shareholder and wear those different hats. And if those relationships are also going to be ended, then we need to make sure the paperwork covers all of those different things and it's all tied up at the same time. I sometimes see the wrong signature clauses as well. There are some circumstances where we would want the settlement agreement to be signed off as a deed, in order to deal with things like powers of attorney in relation to intellectual property, for example. And sometimes I see employers getting that wrong, so it is worth making sure we've got the right signature clauses on the document to reflect the other terms of the agreement as well. We often want to include something at the end of a settlement agreement called an entire agreement clause, to make sure that it's only what is written down in that agreement that is binding between the two parties. That's a protective mechanism again for the employer. If you do have any questions, please do not hesitate to contact me. It's adenton@Refreshing Law Limited, Ltd, that is, .co.uk. Thank you very much.